and I thought it would. I do my best to start hearings on time and don't like to keep a large crowd of folks waiting for me, so apologies for that. But I am happy. We are proceeding this afternoon at this first day hearing by way of Zoom, and I am happy to pass the virtual podium to counsel for the debtor to take us through our agenda this morning. Mr. Riley, do we start with you?
Good afternoon, Your Honor. Patrick Riley from Cole Shots on behalf of the debtors. Your Honor, before we start, we'd like to thank Your Honor and your chambers for making time for us today. We appreciate you fitting us in for this first day hearing. We'd also like to thank Mr. Bates from the Office of the United States Trustee for his efforts in reviewing our first day papers and providing comments and working with us to try to resolve most, if not all issues. Your Honor, before turning to the presentation and matters scheduled on the hearing agenda, I would like to introduce my co-counsel from Kirkland & Ellis. I'm joined on the Zoom by, I see Anup Sathi, Josh Sussberg, Aparna Yanamandra, Jeffrey Mahalik, Lindsley Blumenthal, and Olivia Kuna from Kirkland. In terms of proceeding, I believe Mr. Sussberg was going to make some introductory remarks. So with that, I'll cede the podium to Mr. Sussberg.
Okay.
Thank you, Your Honor.
Thank you, Mr. Riley. Mr. Sussberg.
Judge Goldblatt, it's good to see you. I had to invade Ms. Yanamandra's office because my Zoom was not working. So apologies for the double picture. I wanted to make a few comments. We know that Your Honor is very familiar with JOANN's because you presided over the first Chapter 11 case, and we don't want to dive into the past. But I am reminded when I think about that of Shakespeare's famous quote, "What's past is prologue." And I say that because as a company side attorney, I have found that while you can't escape the past and sometimes you inherit it, the true focus needs to be on the here and now. And I want Your Honor to know that that is our focus. And I speak for Mr. Sathi and Ms. Yanamandra when I say that. Of course, Your Honor, you're accustomed to this. You're going to hear some noise today about what happened in the past, what happened after the last Chapter 11. Fortunately for us, it's our 1 month anniversary as of today, so we're not burdened by that past, but we will address that past and deal with it. And we don't want to sugarcoat anything. Your Honor saw, and Ms. Yanamandra will explain, that we have a bid from Gordon Brothers for all of our assets, and it would result in a liquidation of JOANN's. And it's an 80-year-old company that has served many, many needs of the communities for a long time. And what we're going to do, and our job, is to do everything in our absolute power to try to save it. And we are working very closely with the advisors, and you'll hear about Centerview and the process we're running. And the one thing we can promise all the employees, everybody at the company, all the loyal customers over the years is you will get 110% from the advisors here to try to save this company. And we've set up a process that will allow us that opportunity. Having grown up in Cleveland, Ohio, I am very familiar with JOANN's, and you know the whole history. But interestingly enough, I actually grew up with the great-grandson of Betty Rosscamp, who started the company. We played youth sports together. And I did realize that I had never been to a JOANN store. My mom, my wife, they go to JOANN's. There's one in town, but I hadn't been, and it didn't feel right. So yesterday, I went to JOANN's. I wanted to wait until post-petition. I didn't want there to be any potential transaction that would involve us or create any issue. And I went and I walked the store, and believe it or not, I found a whole host of things that I didn't even know I needed, but I wanted. And I actually have the receipt to prove it. This is absolutely true. And I got the bag from JOANN's. I got picture frames for my office. I got my wife a Valentine's Day gift. I got Sharpies. And of course, I bought the famous yarn at JOANN's, my favorite color, green. I'll figure out how to use that at some point. But I realized as I was walking through the store, which was fully stocked and pretty crowded, believe it or not, that there were people with children. There were older people. There were all sorts of walks of life going to JOANN's to satisfy crafts, fabric, whatever their needs. And our hope is that we are able to successfully find someone in the investment community that believes in that thesis, because there are people out there that have relied on this company for 80 years. And again, Your Honor, you have our commitment to do everything in our power to try to save this business and all of the jobs associated with it. With that, I'm going to hand it over to Ms. Yanamandra to get into the substance, and we promise we will be brief today, Your Honor.
Okay,
Thank
very
you.
well. Thank you, Mr. Sussberg. Your Mandra.
For the record, Your Honor, Parna Yanamandra from Kirkland & Ellis, proposed counsel to the debtors. Let me just first round out two additional introductions. We have Mr. Michael Prendergast, the interim CEO of the company. He was our first day declarant, and he is available on camera as well as Mr. Jeffrey Dwyer, the interim CFO, who is our declarant on cash collateral and who is also available on camera. Your Honor, we are taking a bit of a controversial position today. I don't have a first day PowerPoint presentation for you, and I won't belabor some of the points that Mr. Sussberg hit, but I did want to provide a little bit of context on sort of what happened between the emergence of the first bankruptcy and where we find ourselves today, because I think it does inform how we collectively approach the second trip into bankruptcy. As Your Honor knows, the first bankruptcy was a pre-pack. And despite a massive and thorough communications and PR rollout plan, vendors who had been burned in other Chapter 11 cases were rightfully uncertain about the outcome. And so we saw, as we often do, some level of drop in production during the case. Now, when the company successfully emerged, those production levels picked back up and vendors turned back on once they realized that the company was out of bankruptcy and pre-petition claims were being honored. Unfortunately, for a lot of our most profitable goods, our specialty goods and fabrics in particular, the production timeline on those goods can be uncertain. And so while the hope and expectation was that the, quote, turn back on would result in goods hitting the shelves in relative short order, the reality is it just took longer than anyone anticipated. And so having emerged in April 2024, it wasn't really until late October or November 2024 that we actually saw those goods hit our shelves again. Now, the good news is that when that happened, the investment thesis proved true. People were buying the goods and products off the shelves. And in December and January, we actually started to comp up for the first time. And that is part of the thesis on what makes us all so strongly believe that there is going concern value here. That being said, the damage was sort of done during the interim delay between April and this late October, early November period. Without the inventory we needed, we weren't hitting the sales we needed, we weren't creating the revenue we needed, and the inventory we did have was getting degraded along the way. And against the backdrop of all of that, our ABL and FILO lenders did what they're entitled to do under the credit agreement, which is they started imposing reserves. Now, over time, those reserves, as you might imagine, crippled our liquidity and our ability to borrow, such that by the time we got to the mid-December-ish timeframe, we found ourselves in cash dominion. And in order to prevent a precipitous event of default and disorderly chaos from being triggered, we entered into what I'll call consensual cash dominion, which means we basically negotiated a new budget every week. Now, to the credit of the lenders, that budget allowed us to operate in the ordinary course. And most critically, we paid payroll steadily without any disruption, which is also what we intend to do during the case. But certainly, it is not in the best interest of any company to operate on a week-by-week basis. And so we all knew that we were sort of bridging to a more holistic solution. And over that same time period, it became clear, including through Centerview's efforts, that we were not going to get rescue financing from either within the capital structure or outside of it. And so a Chapter 11 quickly became the only responsible answer instead of living in this week-to-week purgatory. And as Mr. Sussberg said, and I certainly don't want to shy away from it either, we are disappointed. This is not the result the company wanted. This is not the result our capital structure wanted. The folks who believed in this company and supported it the first time around, this is not what they wanted. Those lenders that sort of held hands with us on our way into Chapter 11 this time around are holding our hands, but certainly this is not the outcome they want. And as you'll hear from Mr. Brody on behalf of the term loan lenders who made meaningful investments in this company in the first bankruptcy, they are extraordinarily disappointed in where we find ourselves. And we hear that disappointment, we feel it too, and it was a component part of how we as restructuring advisors approach the reality that, retailers don't do well in Chapter 11. We all know that. They face the employee attrition, vendor attrition, customer attrition. Time is often not their friend. And there's no doubt all those issues are magnified when it's a second return trip to Chapter 11. And so our job kind of became, how do we preserve and maximize value under these exceedingly difficult and unexpected circumstances? And we approached it really with two key principles in mind. The first, which Mr. Sussberg touched on a bit, is we were not going to run this case on the backs of administrative claimants. I think everyone in this Zoom, all 147 of us, have almost certainly been part of administratively insolvent cases, and we know how quickly those cases can take a turn. And as I'll talk about in a moment, we pulled every lever we could to ensure that that was not going to be the outcome here. On the other hand, as I said, we believe that this company has potential and has value if given the opportunity to realize upon that value. The best evidence of that is December and January comping up once we actually hit the inventory levels that we hoped we would hit earlier in the timeline. And of course, we didn't file this case as a pre-pack, so we have other tools in the code to shed, overhead expenses and OpEx. So there is an opportunity for success here, but of course, those two goals compete a bit because we need time to realize upon potential, but time is not our friend, and time comes with costs, and cost is not any retail company's friend. So we took all of that in stride and launched, I would say, 3 kind of key pre-petition initiatives to put us on the best possible path to as successful of a Chapter 11 case as possible. The first was the marketing process. We are now about 30 days into the marketing process. Centerview reached out to over 50 parties, approximately 20 of whom are in the data room and doing work. They reached out to a whole strata of types of investors, PE funds, strategics, landlords, anyone who might have any conceivable interest in any asset of value here. And so I want to say, for the 147 folks that are listening, if we have not already found you and you have an interest here, please come find us, because we are willing to talk to everyone, and we want this to be a come one, come all process. Second, again, recognizing that often a very vulnerable area for a retail company, and often the difference between administrative solvency and insolvency, is the unexpected 503b9 accrual. Once it became clear that we were potentially within a 20-day window of a filing, we very carefully monitored the inventory we were taking possession of in order to try to put some downward pressure on that number. And I think overwhelmingly we were confident in where we landed in keeping that number to a manageable level. And I would say the third piece of it was we, of course, went to our lenders and said exactly what I've said to Your Honor, that we believe this company has value. We need to finish the process that we've started to try to realize upon that value. And we need your support, and we need, more critically, your money in order to accommodate that. They said, we understand, but we need you to go into Chapter 11 with the stalking horse bid, because if you run your process and it fails, we need to know that there is effectively a backup plan in place. And so our goal was to not only effectuate a soft landing, which we'll get into once we get to the agenda, first day motions and cash collateral, but also to give ourselves the time and runway to complete that process, the price of admission of which was a stalking horse bid. So the results of all those efforts over the past, I think Mr. Sussberg said it was about our 1 month anniversary. So the results of about a month of work is not only the suite of first days, but the agency agreement we filed with, as well as our agreement on cash collateral. And the two dovetail, so I'll touch upon them together. The agency agreement with Gordon Brothers is effectively our stalking horse bid. And as Mr. Sussberg said, it is a liquidation bid. They will be the agent to liquidate all of our assets. That bid has a couple of key parts that are worth mentioning, although obviously none of it is up for approval today. The bid contemplates paying off the ABL and FILO in full. The bid contemplates liquidating term priority collateral and currently does not provide a recovery to term priority collateral. Mr. Brody will mention this as well. I say it so that Your Honor knows we recognize that that is an issue and we've been working through it, and I'm confident that once we get into a soft landing, it will become a very high priority focus for all of us. From our perspective, the bid also has what's referred to in the papers as a wind down budget attached. That wind down budget is basically our proxy for projected administrative claims. The word exhaustive does not begin to describe it. It was exhaustively negotiated and vetted. And it, for example, includes the payment of all projected 503b9 claims and the payment of stub rent in the week ending April 26th. And so while there are no guarantees in life, a lot of thought and attention has gone into reaching agreement on a budget that allows us to pay all projected administrative claims. That also includes time and money to ideally confirm and consummate a plan of liquidation at the end of this sale process if one is so required. That bid, and as Your Honor may have seen, we also filed bidding procedures. The bidding procedures, the agency agreement, and the cash collateral order all have the same rough timeline in there, which is about a 30-day sale process. And so just to hit the high points on the timeline, we contemplate a February 12th qualified bid deadline. If nobody shows up and there's no need for an auction, we'd contemplate a Valentine's Day sale hearing and then start the liquidation the next day, which is a Saturday. There is some magic around starting on a Saturday. If bids do show up and we do need to have an auction, then that sale hearing would move back by a week. And here's where kind of the pieces of the marketing process, the agency agreement, and cash collateral all really kind of coalesce. We often, as debtor advisors, say to Your Honor that our timeline is fast but fair. I think the better characterization here would be fast, fair, and responsible. Because during that 30-day process, the cash collateral budget allows us to operate the business approximately in the ordinary course. It's not going to be exactly as it was during the pre-filing period, but in addition to, for example, paying payroll and rent and taxes and all the normal OPEX, it also contemplates that we are taking an inventory, obviously on a reduced basis, but taking an inventory and then selling it in the ordinary course. And so I say that to say that the criticality of being able to operate the business as a going concern over the sale process timeline cannot be overstated. The last thing that we wanted to have happen, and a critical point from the company side, was that we didn't want it to become a fait accompli that no going concern buyer would show up because we weren't able to operate the business in a normal way over the course of 30 days. And so the price of admission for being able to operate in the ordinary course for 30 days and maximizing the likelihood that we get a higher, otherwise better bid was this tightened timeline. And of course, everything ties to this timeline. The wind down budget and the projected admin expenses are tied to this timeline. The cash collateral consent we have is tied to this timeline. And so I wanted to take a minute and just kind of highlight that, yes, the timeline is aggressive and we understand that and we own it. But part of why we thought starting off the case in that way made sense was because the trade-off was being able to run a sale process over the next 30 days that would be attractive to any potential going concern buyer and not just potential liquidators. Now, all that being said, we know a committee may be appointed here, and our job will be to explain this to them, either get them on board or come back to Your Honor when these dates are actually up for approval and make our case at that point. But I wanted to simply provide that context heading into the first day.
Okay, so let me say I appreciate everything you just said, including the point that there'll be a committee, and so I don't think I should say more today, other than I understand your point, and to the extent there's a dispute down the road about timeline, we'll address it. But I don't think I don't want to say anything that anyone construes one way or the other for the purpose of what is necessary and appropriate to be part of a bankruptcy process. I'll allow this to proceed, and we'll address disputes as they arise.
Understood. Thank you, Your Honor. And again, none of these dates are up for approval today, so completely understood. The one thing we would ask, if Your Honor is amenable, is simply that you hold February 14th, if possible, just reserved on your calendar. And the reason, in addition to knowing the time is available, the other reason I make the ask is we would want to send out what I'll call kind of a conditional notice at the end of next week, saying something to the effect of, the debtors have filed bidding procedures. Those procedures have not been approved by the court. They may never be approved by the court. As filed, they request a 2/12 qualified bid deadline. So if you'd like to participate, you need to effectively be ready to go as soon as 2/12. And if you choose not to participate, the court may consider another bid on 2/14. And again, we'll make it abundantly clear none of this has been approved. We just, for anyone who did not read the thousands of pages we filed on 24 hours ago, we just want everyone to be on notice that is the earliest date they may have to be ready if they're interested.
Okay, so I completely understand what you're saying. I am available on February 14th and will be available to the extent there's a need for a hearing. To the extent you're going to tell folks things that I haven't approved, I appreciate you're telling me that you're doing it, but because the whole point of it is that I haven't approved it, I don't think I need to say more about it.
Understood. I completely agree. I just didn't want Your Honor to be surprised if you saw something in the docket.
I very much appreciate the disclosure. I do find that to be very helpful, so thank you for that. I don't mean to be unappreciative. I just want to be careful. I just want to be careful.
Understood. And so, Your Honor, with all that, I'll just simply wrap by saying, again, this is not where anybody wanted to be. First and foremost, the company, and we certainly understand the frustration of everyone who's had to help us get here and the constituencies that we fully intend to keep working with. And, against what's been a pretty challenging backdrop, I think from our perspective, we've been able to file these cases with a budget and agreement that allows us to land a going concern, if there's one out there to be landed, and a stalking horse bid, which we hope to approve upon, but does come with the support of administrative solvency, which is not something any of us take lightly these days. And our goal from here on out is to engage quickly with the committee if one is appointed, continue engaging with the term loan lenders. We think this case screams for consensus, and that's what our goal will be on the company side. And of course, all of that starts with our soft landing in here. So I know there will be others who want to speak first, and then after that, we can turn to the agenda.
Okay, very, very well. So, Mr. Brody, I see you've turned on your camera. Let me give you the chance to be heard.
Thank you, Your Honor. Much appreciated. I hope you can hear me okay.
I can. You can proceed.
Okay, thank you. For the record, Josh Brody, Gibson, Dunn, and Crutcher on behalf of the ad hoc group of term lenders. As noted in our 2019 statements, our clients hold approximately 60% of the term loan, and I think a roughly similar percentage of the equity, although I would imagine that number may grow based on some of the outreach we have received already. And I am happy to see Your Honor again, although to be totally honest, I really didn't think I would be seeing Your Honor again for JOANN stores. And while I'm appreciative of my good friends, Mr. Sussberg and Ms. Yanandra, giving some background, and Mr. Sussberg's comment in particular about not being burdened by the past, I can appreciate that may be true for the debtors professionals. Unfortunately, the past is prologue, as Mr. Sussberg also noted. And I think a little bit of history here, I think, actually is somewhat important. If Your Honor will indulge me just for a moment, I'd like to give a little bit of a different perspective on A, how things got to where they did, and B, where we see these cases going, which I think is a little bit different than debtors counsel may have noted. First, I would say I don't think that I expected, or my clients expected, that we would be back in Chapter 11 just 8.5 months after exiting previously. And from the outset, I would note that the case trajectory that Ms. Yanandra noted, that we see that we view as being imposed by the ABL and the FILO lenders, pretty much guarantees that while they may have hope that they're going to find a going concern bid, we do not think that the timeline that they are currently projecting and that they are proposing is actually going to end up giving us a bid. We think it is way more likely, if not a certainty, that this company is going to end up in liquidation. Some 19,000 employees are going to lose their jobs, and the only parties that are going to get any recovery out of this case are the ABL and the FILO lenders. Nobody else is going to see anything. And again, as I noted, the history here is important. When we came in front of Your Honor less than a year ago, we had a fully consensual prepackaged case pursuant to which my clients agreed to give up and equitize $660 million of secured term loan, in addition to investing another $100 million of new money in order to give the company and help position them for future success and for a turnaround. And that plan, Your Honor, not only left trade creditors unimpaired, fully unimpaired, it left the ABL and FILO lenders unimpaired as well. Now, we did that, including investing additional money at the time that came in junior to the ABL and to the FILO, because those lenders were unwilling to make any concessions at that point, and we saw it as the only way to help preserve the company and give it a chance at success. Now, if you fast forward to today, Your Honor, yes, the company has struggled with its vendor base. And as I'm happy that Ms. Andra noted, it's not just the vendor base that was the problem. As she noted, the ABL and FILO lenders put in a number of significant reserves, which we understand was in excess of $100 million. And while, again, Ms. Andra noted that this was their right to do so, I'm not so sure from my perspective, my client's perspective, Your Honor, that it's quite so simple that the perspective that they took actually is correct. And for example, Your Honor, this is not a new problem that somehow in the last couple of months that the ABL or the FILO lenders put in these reserves. Back in as far as August, maybe a little more than 3 months after the company exited Chapter 11 the first time, we understand that the FILO lenders tried to put in a $10 million reserve, and the company disputed it and did not think that it was actually appropriate. I don't know the outcome, and I think, frankly, there's going to need to be some discovery and investigation then to figure out what exactly it was that happened in terms of how the ABL and the FILO lenders choked this company's liquidity, which massively exacerbated the problems they were having with their vendor base. And so from our perspective, Your Honor, not only is that potentially what helped push the company into Chapter 11, now the company's in Chapter 11 on a timeline that, with all due respect to the Debtors Council, it's not a timeline that is realistic to get a good bid. The company has not had enough time to actually really market these assets, and they're looking to have assets, a bid procedures process that's going to run essentially at best 30 days from today. In fact, I think the bid procedures motion, which again I appreciate is not in front of Your Honor, although I will come back to that in a second, but the bid procedures motion as constructed seeks to have the bids due 27 days from today. Now, what I have not heard anyone say or mention is that the stalking horse bidder, Gordon Brothers, is actually an affiliate of one of the FILO lenders. So this is not something where the debtors went out and found a third party who was willing to come in and put with some liquidation bid. This is actually one of the FILO lenders that seems to have been working with this concept for quite some time. This is not something new. So it's a little bit hard for us when we look at it to escape the conclusion that what's happened here is that the FILO lenders help tighten the company's liquidity and put them into a process in Chapter 11 that all but guaranteed that they're going to liquidate this company, make sure that the ABL and the FILO gets paid in full, and that the stalking horse bidder, again, also related to one of the FILO lenders, takes all of the value which, by the way, in the ABL collateral, my clients have a lien on it. But to the extent there is excess value there that's available, it's something my clients should be getting. But under the construct of the Gordon Brothers bid, we won't see a penny out of that. So make no mistake, if this case moves forward on this trajectory, the only parties that are going to come out okay, if not great, are the ABL and the FILO lenders, and every other party is going to be left holding the bag. And candidly, Your Honor, this is not something that should be happening. This is not the way, and I agree with Ms. Yamandra on this point. I could not agree with her more. Mr. Sussberg, I think, made the same point. This is not the way this should have gone. But what's happening actually is, because while the bidding procedures motion is not in front of Your Honor today, the milestones contained in the cash collateral order essentially dictate that same outcome. Because if the milestones are not met, and as Ms. Yamandra noted, the milestones line up between the cash collateral order and the bidding procedures. If those milestones are not met, the company's ability to use cash collateral is terminated.
All right. So, Mr. Brody, can I stop you for a second? So, look,
yes.
I've dealt with that problem before, right? My usual approach to that issue is to say, if it's the debtor's judgment that agreeing to these milestones is appropriate, then I'm not going to stop it. That said, if and when I have a dispute about what process is appropriate, I'm going to make my best judgment about what process is appropriate without regard to the fact that the milestones say what they say. If that happens to cause an event of default and permit the lenders to, enforce remedies outside of bankruptcy, then so be it. I've not seen that happen before. But, again, I'll hear this as it arises, but I haven't in the past been overly concerned about the milestones in an interim dip order, because I don't take that as precluding me from entering whatever ultimate relief with respect to bid procedures, final dip approval or final. No, sorry, it's the cash collateral, not the dip. If I said dip, I misspoke. But in any event, I don't view that as tying my hands. I think that we'll deal with the future motions as they arise, and I'm not losing too much sleep over the prospect that what will happen is someone will decide it's best for them to proceed outside of bankruptcy. Does that?
Well, thank you, Your Honor. Look,
am I missing something?
Sorry, Your Honor, go ahead. No, Your Honor, I understand that. Look, I appreciate those comments, and I think to some extent that is definitely helpful. Because, again, to state the obvious, I would imagine that come the hearing on the bidding procedures motion, whenever that happens to be, that one of the things that debtors and the ABL lenders and the file lenders are going to say, oh, Your Honor, you have to approve these bidding procedures as is, or otherwise the debtors are going to lose access to cash collateral. So as I'm hearing, Your Honor, that your response may be, well, okay, if that's what Your Honor decides is the right answer, then so be it. That certainly, I think, addresses a significant amount of what our concerns are. But, of course, Your Honor, it doesn't end the problem, because I want Your Honor to appreciate, and frankly, all the parties into this case, including the debtors and the ABL lenders and the file lenders, to understand that our perspective here is that what is being put in place is basically something that could not happen outside of Chapter 11. As Ms. Namandra noted, the stalking horse bid involves the file lenders taking my client's collateral and not paying anything for it. You cannot do that outside of bankruptcy. Frankly, inside of bankruptcy, that does not seem at all legal. And that is exactly what the debtors have agreed to. And I appreciate that maybe they didn't have a choice and they felt they needed to get something to get the process started. But it's important for me and for my client that Your Honor understands and appreciates kind of where this is positioned to go. And it doesn't make any sense to us that anything that's going to happen today is going to lock that in.
Okay.
Again, I'm hearing Your Honor pretty loud and clear that that's not Your Honor's concern.
So that's where
I'm not concerned about it.
Right. What I said about the consequences of interim approval is what I've said on the record in any number of cases before. That's my view. Look, I understand that no one is happy that we are where we are. And I understand that there are any number of disputes that may arise in front of me in the future. I do want to be sensitive, as Ms. Yenaranda and Mr. Sussberg point out, that we are today dealing with, something of a fragile situation. And so for today's purposes, to the extent folks want to let me know about disputes that may be coming down the road, I'm happy to hear it, and I find that to be helpful. But I at least want to be reasonably circumspect in how I comment on that in order to not inadvertently do anything that is disruptive of the efforts to maximize value for all. So don't take my uncharacteristic silence to be indifference. I just want to be sensitive to the fact that I don't know what I don't know and don't want to trip on something by accident. So I hope that makes sense and is helpful to folks.
Yes, thank you, Your Honor. I do find that helpful. To that end, I think I want to highlight a couple of other items that relate to the cash collateral order, because it is important. One thing is to make sure it's not lost in all the noise. From our perspective, we want this company to succeed. It needs to find a going concern bidder. We want to make sure that value is maximized for the benefit of all parties and not just one. And so I'm in total agreement with you, Your Honor, that we want this cash collateral. The company needs to use cash collateral in order to operate. And so we want to limit the disruption, but make sure that it's being done in a way that everyone's rights are being preserved appropriately so nobody gets locked in. But I've heard Your Honor loud and clear on that, so I won't push that anymore. The only other things I think I would want to note for the moment, and they do relate to the cash collateral order. But again, I'm assuming that what I'm about to say, Your Honor, is going to tell me falls under the rubric of your prior comments, which is there are releases being granted here for the benefit of the ABL and the FILO lenders. We have, as I noted, some serious concerns about what actually happened leading up to these cases. And so it seems to me there may need to be an investigation. There may need to be some discovery that's going to get served. And we want to make clear that the entry of this order, and whether it's because it's preserved for the final order and or because it's preserved as something relating to the challenge period, is something that is not being locked in today before we have had a chance to figure out, as Your Honor put it, to know what we don't know yet.
Okay, I understand that. The only request before me today is for interim relief. So with respect to final relief, everyone's rights will be fully reserved, and we'll deal with those. I understand your point. It's helpful to understand it. But I also don't want to prejudge it. So I appreciate that, Mr. Brody.
Okay, thank you, Your Honor. And lastly, and this is a much more minor point, which I may need to work out with Ms. Yanamandra just in terms of the language in the cash collateral order. I just did not get a chance to do it before this hearing. There is language in the cash collateral order related to the use of the term lender's cash collateral. Based on the conversation I had with Ms. Yanamandra, I don't think there's any term lender cash collateral that's actually being utilized. But to the extent there is, it doesn't seem that there's any actual adequate protection being provided to the term lenders because they're not getting anything other than liens on collateral they already have. So that may be something that, again, is just really a final order issue because there isn't any term collateral being used, but I just wanted to raise it as something that didn't quite make sense to us.
All right, so why don't to the extent the parties are able, by email even to work through some of that, while we go through the rest of the hearing, if there's a dispute about the language in the cash collateral order, I'm happy to hear that when we get to the cash collateral order. And if it's just a language issue that can be addressed, by people working through it, then I'm happy to give you the chance to do that before I start doing it myself. Anything
okay,
further?
Thank you, Your Honor. With that, then I would see the podium. I have no more comments.
All right, very well. Thank you, Mr. Brody. Mr. Ventola, I see you've turned your camera on. Would you like the chance to be heard?
Thank you very much, Your Honor. John Ventola of Choate Hall & Stewart. I'm here today with my partner, Jonathan Marshall. Our co-counsel at DLA Piper filed a pro hoc motion for us, Your Honor. I don't know if they've been granted yet, but is it okay if I speak?
You certainly can proceed.
Thanks very much, Your Honor. I'll be brief. I know Ms. Yanamandra wants to get to the agenda and the motions, and I'm sure everybody else in the hearing, listening in today does as well. Just to respond briefly to Mr. Brody's comments. The insinuation or statement that the ABL lenders, the FILO lenders, drove this company into bankruptcy is completely unfounded, Your Honor. We represent 1903 Loan Agent LLC, which the parties generally refer to as the FILO agent. And in very briefly, Your Honor, we supported the company with the other ABL lenders in the first bankruptcy case. Our debt effectively rode through, but that case was mostly predicated on paying trade vendors in full and in cash in the ordinary course of business. That was the debtor's decision. It wasn't ours, but we supported it and gave the company another opportunity to succeed moving forward. The debtor's own pleadings, though, Your Honor, make clear that since the first case ended, big picture economic issues really drove against the company. Inflation hurt the company, higher interest rates. And the debtors point out that those macroeconomic factors hurt sales and push consumers to essentials and away from the debtor's product base. That had nothing to do with the lenders, Your Honor. Beyond that, and more specifically, the debtors go through in great detail to their credit, and their pleadings are replete with statements that the lack of vendor support that they expected, since they had paid the trade creditors in full in the first case, didn't happen. And it derailed their post-emergence plan that my client and the other ABL lenders relied on when they supported the debtors through the first case. As the debtors put it, against all expectations, the trade vendor support was not there that the debtors expected, and that had a snowball effect. Suppliers halted production of key items that the debtors needed for their inventory mix, and that had a snowball effect. Inventory levels fell, customers got frustrated at times, and revenue and profitability dipped only months after the debtor got out of its first case. And in particular, the debtors say that their in-stock levels fell well below 90% of their post-emergence plan, which was a key metric for their success. And when they went below that threshold, it drove customers away. And according to the debtors, that was the lowest inventory levels the company had experienced in over a decade. And that happened in the summer of 2024. None of that had anything to do with the lenders, the ABL lenders or the FILO lenders. The vendors made their choice. Those were business decisions by the vendors. And certainly I'm not saying they did anything wrong, but for anyone, including the term lenders, to say that we did something wrong is just completely off base, Your Honor. So if Mr. Brody or his clients or any other party want information from my client, we're here. As Ms. Yanamandra said earlier, we're happy to talk to anyone who wants to talk to us. And we really want to get on with the show here, Your Honor, but I really just didn't feel like it would be fair to my client not to respond, at least briefly. So I'm happy to answer any questions, Your Honor, but I do appreciate the opportunity to speak.
Okay. Thank you, Mr. Ventola. I think it's not that I don't have any questions. I just don't think this is the time for them. So I appreciate your comments. Mr. Carter, I see you've turned on your camera. Let me give you a chance to be heard.
Thank you, Your Honor. Good afternoon. Chris Carter of Morgan, Lewis & Bacchus on behalf of Bank of America as the pre-petition ABL agent. And I won't repeat what Mr. Ventola went through, but we agree with his statements. But just wanted to say a few things, and I'll be brief as well. The ABL agent and the lenders have acted consistent with their rights under the ABL credit agreement that was approved by this court less than a year ago in connection with a plan sponsored by Mr. Brody's clients. So we're unclear as to any confusion by Mr. Brody as to the ABL credit agreement's provisions and the ABL lenders' rights thereunder. Nonetheless, as is clear from Ms. Yanamandra's presentation, the issues leading up to this bankruptcy were outside forces which resulted in liquidity issues and reduced availability, as Mr. Ventola just went through. What you did not hear from Mr. Brody was that there has somehow been a missed opportunity or alternative path. And you did not hear from him about a commitment to fund the case or operations. Instead, Mr. Brody would like the ABL and FILO lenders to permit the debtors to use even more of the ABL priority collateral to fund a longer process. There are many issues with that, not all of which are before you today, but the biggest issue is this. After an already commenced marketing process a couple months ago, the debtors have in hand a viable stalking horse bid, a bid that would, among other things, repay the ABL, FILO, and FILO lenders, but also ensures that there's sufficient wind-up budget for the administrative claims. Without that stalking horse on this timeline, this case looks very different. Not only are the ABL lenders not willing to go deeper into their collateral coverage, but the risk of losing the stalking horse bidder would only result in the accrual of post-petition admin expenses, potentially without the ability to fund them. The ABL agent and the FILO agent have been working with the company for many weeks now, funding amounts necessary for the company's operations, payroll, and other amounts as the company, with its sophisticated advisors, sought a path forward to address its liquidity issues and defaults under the ABL credit agreement. And we're here today with a bird in hand on a timeline that the debtors and their advisors support. The debtors have the ability to seek out and obtain higher and better bids, but losing the bid in hand without any other party currently proposing some alternative path or funding source is not an approach that the ABL lenders are able to support at this time. So the milestones are the result of a combination of the budget outflows, expenses, and the stalking horse conditions precedent. As is clear from the budget, every week is another dollar being paid from the ABL priority collateral that puts the ABL lenders and administrative insolvency at risk. The debtors and the ABL lenders have therefore agreed on a schedule that reduces risk, but also provides sufficient time to finish the marketing process to the extent it was not already. As Ms. Yanamandra stated, time is not our friend. So with that, we hope that the parties can come to resolution on any open issues as this case continues forward. But the milestones are very important to the ABL lenders and to their consent to the use of cash collateral. So that's all I have to say for now, Your Honor.
Okay, Mr. Carter, you don't disagree with the point that what the legal effect of the milestones is that if they're missed, it's an event of default and it allows you to exercise your non-bankruptcy remedies, right?
Correct, Your Honor, and this will obviously come up when we talk about the order on a couple open issues. But we agree that any event of default under the milestones or other cash collateral termination events as defined in the order would result in potentially a notice being presented by us and a remedies notice period. So the parties would be coming before the court and seeking this court's ruling before what happens next, Your Honor. Right. So it is a matter for another time.
Got it. Okay, that's what I wanted clarity on. I hear your points. I understand where we are. It does seem to me that all of the parties, for today's purpose, share a common interest in maximizing the value of the estate, and that the relief that the debtor is seeking in the first day motions is designed to accomplish that end. I understand there are other issues that will come before me, perhaps. Maybe they will, maybe they won't, and everyone's rights on those are reserved, and we'll deal with those if and when we get there. But I do want to stay focused on what's in front of me today, which is about making sure that, between now and then, the debtor can operate its business in a way that, serves its constituencies and maximize value for all stakeholders. So I appreciate the comments, and I'm happy to go. Is there any other party that wants to be heard preliminarily before we address the first day relief? Okay.
Yes, this is Eric Wise from Alston and Bird.
Okay.
On behalf of Project Swift LLC, which is a minority holder of the term debt. Our client is not part of the ad hoc group that's represented by Mr. Brody, but we are part of that, the term loan. And our client came in March and April to fill out the DIP to really make the last case work. And our client did so because they believed in JOANN, and they still believe in JOANN as a prospect, as a going concern. So I don't want to repeat things. We do agree with the objections and concerns of Mr. Brody of Gibson Dunn, but you can imagine our client's enormous disappointment and disbelief to have come in March and to be here. And our big concerns are, of course, that the proposed liquidation process is a stalking horse bid, which is quite opaque. You really have to go through the budget to figure out exactly what's happening with quite detail. The budget has almost no line item detail that you would normally expect to see in a case. And it admittedly leaves term loan secured parties with no recovery from the sale of their property. And I don't think that that's even constitutionally permissible. So I think what's been put in front of the court, obviously, is just the cash collateral, but the cash collateral order is pointing in the direction quite clearly of something that's impossible to do, I think.
All right, but let me stop you, Mr. Wise. I understand what you're saying,
sure.
but I really do want to be focused on the matters that are before me today. I understand that you've got issues with the agent agreement and the disposition of your collateral, but I don't believe that anything before me today prejudices your right when that motion is heard to make whatever arguments you want to make. So I understand your position, but I would like to focus on the specifics of the first day relief the debtor seeking, the orders that would, we would enter promptly. Is there anything further that relates to that I should hear?
No, I'll just say that the main point was to make sure that whatever we're doing today does not put us in a position where, as a practical matter, the train has left the station, and I hear the court that's not going to happen, and so I appreciate that. So I'll close with that, and thank you, Your Honor.
Okay, very well. Thank you, Mr. Wise. Okay. So let me turn back to the debtor. Is there any other party in interest that would like to be heard preliminarily? Mr. Mikulak?
Your Honor, Mr. Mahalik is with the debtor team, so there's no one else we can.
Got it. Okay. Thank you, Mr. Mahalik. I have mispronounced your name in every case, so I wouldn't want this to be the exception.
I'd hate this to be the first.
Well, rest assured. So my apologies. But let me allow you to present your motions.
Thank you very much, Your Honor.
For the record, Jeff Mahalik, Kirkland & Ellis on behalf of the debtors. So before we get into the motions, I do just want to echo Mr. Riley's comments from the outset. So thank you, and thank you to your chambers for accommodating us this week. But also thank you to the U.S. Trustee's Office for working really quickly with us to make sure that we have significantly narrowed the scope of what's actually open today. So first, as a housekeeping matter, we have two declarations to offer in evidence for the purposes of today's hearing. Our declarants are Michael Prendergast and Jeffrey Dwyer, the debtor's interim CEO and the interim CFO, respectively. Both declarants are on the Zoom and available to testify if anybody has any questions. So first, with respect to the declaration of Mr. Prendergast in support of the first day motions, that's at docket number 5. And at this time, I'd offer that into evidence for the purposes of today's hearing.
Okay, is there any party in interest that objects to the admission of the Prendergast declaration at DI 5? Okay, seeing none, the declaration will be admitted. Is there any party in interest that wishes to cross-examine Mr. Prendergast with respect to the matter set forth in the declaration? Okay, seeing none, Mr. Mahalik, you can proceed.
Thank you, Your Honor. Next, we have the Dwyer declaration in support of the cash collateral motion. That's attached to the cash collateral motion at docket number 6 as Exhibit B. And at this time, I'd offer that one in evidence for purposes of today's hearing.
Okay, is there any party in interest that objects to the to the admission into evidence of Mr. Dwyer's declaration, which is attached to the cash collateral motion? Seeing none, the declaration will be admitted. Is there any party in interest that wishes to cross-examine the declarant? Okay, seeing none, you may proceed.
Thank you, Your Honor. Turning to the agenda, the last housekeeping matter, agenda item number 1 is our joint administration motion filed at docket number 2. We're just seeking joint administration of the debtors' cases for procedural convenience rather than any substantive consolidations. So we confirm with the U.S. Trustee's Office that they're signed off on that order. We're not aware of any issues or comments to that one, and so we'd ask for that order to be entered.
Okay, is there any party in interest that would like to be heard with respect to the debtors' joint administration motion? Seeing none, I've reviewed the motion and order, satisfied the relief sought is appropriate. We will enter that order.
Thank you, Your Honor. Next, we'll tackle the cash collateral motion. So I'll jump to agenda item number 4. The motion's filed at docket number 6. We also, right before this hearing, filed a revised proposed order at docket number 88 with a red line. So as Ms. Yanamander discussed, we're seeking use of cash collateral to fund the Chapter 11 cases. And as evident from what we filed and the conversations we've had today, we are using the cash collateral to maintain the debtor's business to the greatest extent possible while we run the post-petition marketing and sales process to get us to an auction or the close of the stalking horse bid. As Mr. Dwyer's declaration demonstrates, the company's access to cash collateral is about as critical gets. The order contains adequate protection packages, stipulations, releases, milestones, and other protections that were critical to induce the ABL and the FILO lenders to consent to our use of their cash collateral as set forth in the budget. We worked with the Office of the U.S. Trustee and a handful of other stakeholders and believe we've significantly narrowed the list of open items down with respect to the interim order. So at this point, I'm happy to walk you through the red line, or otherwise I can proceed to addressing what we view as the few open items left.
So let me say the following. I was on the bench in the period right before we started, so to the extent red lines came through this afternoon, I haven't generally worked my way through them, though as we were speaking, I flipped through the cash collateral order and the changes that I see, all make sense to me. So I don't think you need, for my benefit, to walk through the changes, though to the extent you want to make a record, I'm not going to stop you. But to the extent there are disputed issues, it seems like we ought to focus our attention on those.
Great. Happy to do so. So first, just to address Mr. Brody's comment, and this is a comment I previewed making on the record with counsel to the ABL agent. This order and what we're doing pursuant to the interim order, we're not seeking permission or attempting to render any of the term priority collateral to cash proceeds. under the interim order. I believe that was Mr. Brody's concern. And so I'm happy to say that onto the record.
Okay. Mr. Brody, does that representation get you through your day, or do you need language in the order?
No, that's fine. Again, at the risk of repeating myself, we'll deal with adequate protection issues if and when we get to the final that they're going to be using. But that the term collateral at that point. But for now, that's satisfactory.
Okay, very well. Thank you. That's helpful. Mr. Mahalik, why don't you go to the next issue?
Absolutely. So the next thing is I did promise to read this one into the record for folks who've asked for comfort language. So no parties are claiming an interest in or attaching a lien to non-estate property pursuant to this interim order. That includes but is not limited to non-estate property owned by SVP Sewing.
Okay.
So I promised to read into the record, and I see Mr. Harmeyer is on for SVP.
Mr. Harmeyer.
Good afternoon, Your Honor. Andrew Harmeyer of Millbank. I'm here on behalf of SVP Sewing Brands, which also does business as Singer. My client is a manufacturer of sewing machines. We're a vendor to the debtors. And we also operate stores within certain JOANN store locations. And we do have some goods that are physically located within JOANN stores, but they are not debtor property or state property. They are my client's property. I very much appreciate the clarification on the record from Debtors Counsel, and we do not have any objection to the relief being entered on an interim basis. We will work with Debtors Counsel to settle language that we'd like to be included in the final order, but not an issue for today.
Okay, very well. Thank you, Mr. Harmeyer. That's helpful. I appreciate it. Mr. Mahalik, you can continue.
Thank you, Your Honor. Moving on to what we have left open, and this is subject to the U.S. trustee telling me otherwise. I believe we've narrowed down the list to 3 open items with the U.S. trustee, which I can walk through right now.
Okay.
First, in paragraph 12B of the proposed order, we have some procedure around what happens upon expiration of the remedy's notice period. Specifically, it provides that the pre-petition agent can direct an auction of the collateral after the expiration of the remedy's notice period. And that's important for us from our perspective, that it is upon the expiration of that period. It also provides that the court can order otherwise. So from my perspective, the process would be if there is a cash collateral termination event, the parties still have an opportunity to be heard in the event that we get to the end of that period and the court doesn't fashion relief otherwise. This language is essentially just the agent putting all parties on notice of what it intends to do with the collateral.
Okay. Do you want to? Is your plan to walk through the 3 issues, or for us to hear from the U.S. trustee about this one at this point?
I'm happy to walk through all 3 and then see the podium.
Okay. Very, very well. Okay. So I understand what you say this language does, and we'll hear from them. What's next?
Second is in paragraph 16 on the indemnification. The debtors have agreed to provide the agent with indemnification that is consistent with the terms of indemnification provided under the pre-petition credit agreements. My understanding is the U.S. trustees requested that we provide additional language to this paragraph that says no indemnification can be provided if there's a successful challenge. And so I just want to make 2 points on this issue. The first, in the broader point on the challenge period, I know we've touched on some of the issues that a challenge period would be relevant to. We take some comfort in this one that a lot of what an investigation that would support a challenge has already been addressed. All the pre-petition debt we're talking about in this case was the exit debt from the previous case that was all incurred and approved of by this court's confirmation order. It was also automatically perfected pursuant to that confirmation order. And so at least with respect to lien perfection and priority issues, that should be resolved fairly quickly in any investigation under the challenge period. So that's the first point I just want to make generally about all challenges that could come pursuant to the challenge period. Turning to the indemnity specifically, we don't think that it's necessary to specifically rule out indemnity in the event of a successful challenge. Upon a successful challenge, the court can fashion any remedy that it sees fit. And so if we get more specific in this order, I think our concern is that if we're articulating specifics, we could be capping parties' rights to solve for, a hypothetical situation where facts and circumstances of that situation may not justify that result. And so we think it makes sense to leave the provision as is. And in the event of a successful challenge, the court can fashion whatever remedy it sees fit.
Okay.
Third, paragraph 21 provides a debtor release upon the interim order. The U.S. trustees signaled that they'll object to that being provided under the interim order and that should be subject to final. Similar to the stipulations and protections and the other bells and whistles that are in this order, that release was a mandatory piece of the consideration that we provided to induce the lenders to consent to cash collateral. They would not consent to our use of their cash collateral without a release, and so these cases wouldn't be possible. So we agreed to provide it effective upon the entry of the interim order, but the context for that is a debtor-only release. With respect to any other party, their rights are reserved for the final, and they are free to use the benefit of the challenge period.
Got it. So when you say it's debtor only, you mean literally debtor only. If anyone else has the authority to speak on behalf of the estate, that right is preserved.
That's correct.
Okay. I understand your position. Let me hear from those are the three issues?
That's right.
All right. Let me hear from Mr. Bates.
Good afternoon, Your Honor. Can you hear me all right?
I can. You can proceed.
Thank you. For the record, Your Honor, Malcolm Bates on behalf of the United States Trustee's Office. And before I jump in, I will just thank the Debtors professionals for working with us on our office's concerns and helping us to narrow these down to these three issues. And I will confirm that they are the three issues. And Mr. Mishalik, and I hope I'm saying that right, previewed for the court. So I'll just march through them, Your Honor. I'll start with paragraph 12 of the interim order. And Your Honor, I'm referring now to the red line file at docket number 88. And these are the provisions in paragraph 12B. As Debtors Counsel previewed, these procedures generally provide that if there's a termination event, then following the expiration of the remedies notice period, the pre-petition agents can direct the debtors to conduct an auction for the sale of their assets within 2 business days without regard to any pending bidding procedures or milestones. Then the pre-petition agents can require the debtors to obtain an order approving the auction results within another 2 business days, and the debtors waive any rights to seek injunctive or other relief to halt this process. And so our office sees several problems with these procedures. The provision essentially entitles the lenders to take control of the debtors and cause them to liquidate their assets on no notice and without access to cash collateral. The lenders will be forcing the estates to incur significant administrative expenses in the process and will circumvent the requirements of Section 363 and any bidding procedures the court may have approved. And these procedures are made subject to the terms of the pre-petition credit documents, which are not part of the record in these cases. And that's significant in light of Local Rule 4001-2, subparagraph A, Romanet 2, which provides in relevant part that if a cash collateral request incorporates terms from any pre-petition financing documents, those terms must either be set forth in their entirety in the financing motion, or the financing motion must include a specific reference to where such terms can be found in the applicable document, in which case the document must be attached to the motion. And we don't have that here. And so we've got this procedure following the remedies notice period that's subject in all respects to these documents, but we don't know what the documents say and what they actually provide for more specifically on how they might augment this process. And so we would ask that to the extent the court wants to reach the issue today, that these provisions either not be approved or be made subject to final and the party be given an additional opportunity to talk through this issue.
So you're subject to final is a term that means lots of things.
Yes, Your Honor.
Right? I mean, sometimes when we say subject to final, what we mean, like with respect to the 506C waivers and marshalling and the like, is the relief isn't available until a final order is entered. Another thing subject to final means is this is just in place on an interim basis and it's all subject to being changed with respect to the final relief. I proceed on the understanding that everything I do at a first day is subject to final in the latter sense. Right? It's all subject to everyone's rights at the second day hearing to come back and say, Judge, you shouldn't do that. So, Mr. Bates, are you asking for more than the right to continue to negotiate this language, to give the committee the chance to negotiate this language? I mean, to the extent you expressed a concern that it could be inconsistent with bid procedures, for today's purpose, nothing we're going to do is going to be in place until we have final, right? So that issue doesn't arise until the final hearing. So I guess I want to understand whether your objection is essentially we reserve our rights to contend that this language is inappropriate as part of a final cash collateral order, or you're saying it shouldn't be entered on an interim basis.
I think based on how the court has explained its understanding of the subject to final order granting such relief nomenclature, we would ask that this not be approved as part of the interim order. But at a minimum, we would like to reserve both our offices and the rights of any committee appointed in this case to further negotiate this provision if the court's not inclined to grant that.
The second part you have, period. I guess with respect to Mr. Bates, I should know the answer to this, but I confess not to having focused on it. Is this to what extent is this relief different than what is customarily granted first day motions in our jurisdiction?
I'm aware that similar provisions have been granted, and I believe were granted in the first iteration of JOANN, but obviously would note that the posture of that case was different and was not a sale case, was coming in on a pre-pack basis, and not, I think, a primary concern when we were negotiating the financing orders in that case. But I think based on how this case has come in, the anticipated timeline, how the case has been teed up today at the first day hearing, this is drawn our attention and seems concerning given the facts and circumstances that are in front of the court.
Okay, so Mr. Mahalik, you started this when you first introduced the question, but can you try again at a plain English explanation at exactly how you see this mechanic working?
Yes, absolutely. So in the event that there is a cash collateral termination event, right, which it requires a little bit more procedure than just triggering an event of default or a footfall. When there is a cash collateral termination event, it triggers the remedy notice period, wherein parties in interest have an opportunity to come back and request an emergency hearing with the court before the lenders can start exercising remedies. If there is no intervening hearing, there's no remedies or hearing on the remedies, there's not a court order that effectively blocks the exercise of remedies, nothing happens during the remedies notice period, the agent has provided advance instruction to the debtors or has the ability to provide instruction to the debtors to commence an auction within 2 days of the expiration of that period. And so from my perspective, all parties' rights are reserved in that scenario to come back before Your Honor to prevent this from happening in the event that we are in a cash collateral termination event.
Okay, I thought, Mr. Bates, descriptively, do you, and I see Mr. Brody, you've got your hand up and I'll get to you, but Mr. Bates, do you descriptively disagree with that description of what this provision does?
No, I think that's an accurate summary. I do think that it places the parties in sort of the default position that this will occur unless someone seeks and obtains relief preventing it during the remedies notice period. But descriptively, I think that's an accurate summary of what this provision does. Okay.
So, look, to the extent anyone is concerned, and in the event that there's a crisis and there's about to be the exercise of remedies, and the worry is I'm not going to be available to have a hearing to address the concern, I should say don't lose sleep over that. If this crisis happens, we'll find a way, and if for some, surprising reason I'm not able to free myself up, there are 7 other judges on this court, and they'll bail me out. So I'm not overly concerned about it. Seems to me that the safeguards are here. First of all, the likelihood of this in the interim period strike me not as a thing that we shouldn't be talking about, but not as a high likelihood event. And I'm satisfied that I have the authority to protect the estate in the event that were to happen. So I guess I'm inclined to stick to my more minimalist approach that this is what the debtor has agreed to. It doesn't profoundly offend the process, and it's all subject to everyone's rights at the second day to make whatever argument they want. So I guess I'd incline to approve it. But Mr. Brody, you raised your hand, and let me give you a chance to be heard.
Thank you, Your Honor. The truth is, my issue, again, Josh Brody for the record for the term lenders, my issue is really less about this particular point than as it relates to the release issue that was on the list of the U.S. trustees issues that goes to a comment Your Honor made about sort of this dichotomy between the different way the person can interpret what a final order or an interim order means. In particular, with respect to the releases, it's unclear to me if the releases are granted today and then it's, for example, at the final order stage, someone were to convince Your Honor not to include it. What does it mean that it was included today?
All right. Well, so let me stop you there, Mr. Brody, because the releases, I think, are in paragraph 21, which is the third of the three issues. So I'm very happy to hear from you then. But
okay, apologies, Your Honor.
Okay. All right. Okay. So I think I'm going to approve 12B for the reasons I just described, that it's entirely without prejudice. No one should take this as like being green lighted as appropriate for final approval. It's entirely without prejudice to everyone's rights at a final hearing. But I'm satisfied that as far as interim approval goes, there are sufficient safeguards to ensure that I've got the ability, in the event of an issue were to arise, to take appropriate action and grant appropriate relief. So I'm comfortable with it on an interim basis, entirely without prejudice to what I would say about the inclusion of these provisions in a final order. Okay. That brings us to the question of indemnification. And Mr. Bates, I think I already heard Mr. Mihalik's explanation, which is, look, I already have the authority in the event of a successful challenge to enter whatever relief is appropriate, and that saying more about cutting off indemnity in the event of a successful challenge could, if anything, give rise to a negative inference about my other authority in that event, and that it's better to just stick with the general statement than to articulate some but not all of the things that are reserved. And I guess I'm interested in your response to that argument. Well, Mr. Mihalik, did that more or less describe your argument correctly?
Yes, Your Honor.
So what's your response to that?
Well, I think that sort of improperly puts the burden on the party asserting the challenge to take a step further and challenge the indemnification rights, when really it's difficult to imagine a scenario in which the debtor's estates and, by extension, their creditors should be bearing those burdens and should be indemnifying the parties who are subject to the challenge for their costs and fees incurred in connection with that challenge. And so in addition to the issues with that, I mean, one, we don't think that indemnification for pre-petition lenders should be approved in the interim order at all, and that should be something that's the province of the final order. But in addition to that, we don't think there's a scenario in which it would make sense for the lenders to receive this benefit if they were the subject of a successful challenge. And we do think it makes sense to include the additional language.
All right. So let me suggest the following. This is about there being a challenge. There's not going to be a challenge between now and the time of final approval. So this language doesn't have any real effect during the interim period because, there's not a committee in place, et cetera. Why wouldn't it be appropriate here to say subject to the entry of why does it do the lender any harm to begin this paragraph with subject to final approval, comma?
If I may, Your Honor.
Yes.
Chris Carter of Morgan, Lewis & Bockius on behalf of Bank of America, the pre-petition ABL agent. So this is an important provision because the credit agreement makes it clear that the secured lenders, the ABL and FILO lenders, are indemnified under the credit agreement in accordance with that credit agreement. And those provisions apply pre-petition and as we go into the case for whatever may come up as indemnification issues. To the challenge point, a successful challenge by no means means that the lenders could be, are definitely going to be undersecured or unsecured. A successful challenge could be something significantly minor, which is some unperfected account, which doesn't impact anything, but it's just a clarification. Like, there's a lot of things that arise under a potential challenge other than what Mr. Bates is kind of alluding to. But we completely agree that if there's a successful challenge, the court can fashion whatever remedy it wants, which could include this, any indemnification amounts that have been paid being, clawed back or whatever it is. So, we would say that this provision, which is part of our, part of the lender's agreement with the debtors, the credit agreement, is enforceable now until it's not. It's not an item that is subject to some other order. It's a truism, right? It's part of the credit agreement, and they are entitled to these indemnities as secured claims under their credit agreement, unless there's a challenge that the court rules otherwise.
Okay, I hear that. Mr. Marshall, I see you've turned on your camera. Let me give you a chance to be heard.
Yes, thank you, Your Honor. Jonathan Marshall, Choate Holland Stewart, on behalf of 1903P as the FILO agent. I was rising to say the same thing Mr. Carter was going to say about the ability for the court to fashion a remedy if there is a successful challenge. And also, as Mr. Carter said, this is limited to the existing credit agreement that was approved by Your Honor a mere 10 months ago. And as Your Honor, it would come as no surprise to you, as every credit agreement has, there are carve-outs for what indemnification is allowed to the lenders. So if the concern is that there was some nefarious, nefarious activity that is being challenged, I would say that the indemnification provision already addresses that issue.
I see, because this is subject to and in accordance with the existing credit agreement.
Correct, Your Honor.
So I'm not granting, you could argue, you could have a conversation about whether that's the post-petition effect of that promise, but I understand. So I've got to say, Mr. Bates, my instinct here, and I do appreciate these issues being brought to me. It helps me understand what my order says and is helpful to the process. But my instinct is that an indemnity as part of an agreement to lend is sufficiently commercially standard that while I appreciate your point that the circumstances of this case are different from many other cases we've seen, I nevertheless think, that an indemnity in connection with here it's the use of cash collateral, not a new loan, but nevertheless, leaving in place the terms of the prior loan strike me as sort of reasonably commercially standard, and I'm also satisfied and persuaded by Mr. Mahalick's point that to the extent something happens that's in the form of a challenge, no one is disputing, and counsel for the lenders have acknowledged the court's authority to fashion appropriate relief. And that seems to me, that sort of residual authority seems to me to be a better way to deal with the perfectly fair concerns you raise than blue penciling the indemnity provision. So I'm going to approve this as it is, but do appreciate the point being raised. And Mr. Gold, I see you've turned on your camera. Let me give you a chance to be heard.
Yes, Your Honor. Thank you and good afternoon. Ivan Gold for a number of the debtors' landlords. And I didn't want to wade into what does subject to a final order mean, which could be perhaps the subject of a seminar one day. But that drafting is, the more we talked about what that means in other contexts, I have a very minor technical issue, and I believe it could be just resolved with a clarification on the record. And it relates to that same subject to a final order language in paragraph 34. And this relates to the adequate protection liens. The 506C waiver has that same language. I'm just going to use a discrete example. Does that mean the lenders get a get out of jail free card for the stub rent, which accrues between today and the entry of the final order? Or does it mean we visit that issue later? Ms. Yanamandra, in her opening comment, said that the wind-down budget contemplated the payment of stub rent. We obviously, given the timing in this case, haven't had time to assess and test the adequacy of the wind-down budget. We've seen examples from other cases in your building just in the last month where maybe the wind-down budget wasn't what it said it was. But this language just gives us concern
So I'm sorry. Can you point me to the language what the paragraph?
Yes, sir. It's paragraph 34. It's the definition of the adequate protection super priority claims, and this carries over in the definition of liens. And it refers to the priority of the administrative expense claims. This concept appears in multiple paragraphs relating to the 506C waiver. And another place is recital J. Does this attach now? Because everything always says subject to entry of a final order.
Your Honor, just to hopefully speed to the end of this, the 506C waivers and those waivers that Mr. Gold are talking about, they're subject to an entry of a final order granting that relief.
By that you mean but in that context, subject to final order means it is not in effect unless and until a final order is entered, right?
We would, so at the final order, correct. We would be asking for this language to apply upon entry of the final order. It would look back, but there's no prejudice to Mr. Gold making arguments.
Okay, so you're saying once final order happens, it's retroactive to the petition date, but as between now and then, it's not in effect. So if they don't get a final order, it was never in place.
Correct.
Mr. Gold, does that address your concern?
That's the clarification we needed, Your Honor. I appreciate it.
Okay, very well. Thank you, Mr. Gold. Mr. Soka, I'm happy to hear from you, though. If you're on the point we just addressed, I'm happy to hear from you, but I am cognizant of the fact
a different point, Your Honor.
All right. Well, so as I understand it, there were 3 issues that are disputed between the debtor and the Office of U.S. Trustee. We've covered 2 of them. So I guess I'd like to pick up the 3rd before I add other points, if that's agreeable. Okay. Sounds like it is. All right. So the 3rd point that Mr. Mahalik described was the release upon final order. That's paragraph 21. Let me actually make sure I've got the language in front of me. And here, Mr. Bates, I tell me if I am misapprehending sort of standard practice, but it seems to me that it's not that the solution to the concern about the debtor release is the challenge period, and that because this order preserves the challenge period, there isn't a reason why the debtor release should otherwise be subject to a final order in the way that we just discussed with obviously, look, to the extent there is a sense in which everything is subject to final order. And so if we end up with a final order that doesn't include a release, we can talk about what effect the interim order had. My view of that, if and when that dispute arises, is that's always a matter of the court's equitable discretion to protect someone who relied on an interim order. But if there's no final order, there's no final order. So I'm not sure we need to do more here with respect to paragraph 21, unless you think that what I'm doing is inconsistent with normal practice.
I don't know that I would characterize it as inconsistent with normal practice. I would just make the point that I think our office's position is generally that on the first day of the case, it would not be proper for the court to be granting pre-petition releases with respect to the lender's conduct, particularly a release as sweeping as this one, notwithstanding the fact that it's, subject to the challenge period and characterized as being bifurcated between the debtors and their estates. In addition to concerns about the challenge procedures, we don't think there's a record in support of the releases being granted here.
Look, let me say the following. First of all, it's interim, so to the extent someone could come back and tell me otherwise, in connection with final approval, we can deal with that. Second, in terms of a record supporting the release, it seems to me that this is a debtor release, so the estate claims are just estate causes of action. That's property of the estate, and so the record would need to be that there was an arm's length negotiation between the debtor and the pre-petition lenders, under which, in exchange for the use of cash collateral, the debtor agreed to give up the rights that it's giving up here. And to me, at bottom, that is what the Dwyer Declaration establishes. And I don't see a reason why there needs to be more of a record other than an arm's length negotiation, between parties who are both looking out for their own interests. Mr. Bates, do you think it requires more of a record than that?
I think there's a record that there were negotiations with respect to this cash collateral order, and that this was a negotiated term of that agreement. But with respect to the actual specifics of the claims that are being released here, I don't think there's a record with respect to any of that, really. But if the court is satisfied that this is a sufficient record and that parties' rights are preserved with respect to the challenge provisions,
well, it's not just the challenge period. It's also that it's an interim order. And so, anyone can come back, and it's without prejudice to anyone's rights in connection with the final order, and the like. Mr. Brody, I see you turned on your camera. Anything to add?
Yes, Your Honor. I appreciate Your Honor's point about the sort of the challenge period being perhaps the better, or from your perspective or the debtor's perspective, the right angle for another party to raise an issue with the release. I think the problem I have, or the concern I have, is that the challenge deadline is the earlier of the date approving a sale of substantially all of the debtor's assets, which is a month from now.
No, it's not.
That challenge
no, it's not, Mr. Brody. Let me stop you. I haven't set that date, and you reserve the right to say I shouldn't set the date they're asking me to set. So you're right with respect to when the challenge. Everyone's right with respect to when the challenge period ends are preserved for the second day hearing.
Okay. In that case, Your Honor, I will stand down on that point. Thank you.
Anyone else want a chance to be heard?
Your Honor, I would just say I agree with everything you said now. I just want to note for the record that we acknowledge Mr. Brody's objections to the cash collateral order, and we reserve all rights under the intercreditor agreement. That's all. Okay.
Doesn't sound like anyone is asking me to opine, so I'll just stick to doing my job. Okay. Anyone else want to be heard? Okay. So now, Mr. Soka, you also raised a different issue with respect to the interim cash collateral order.
Yes, Your Honor. James Soka of FABSCRAP Shop on behalf of IG Design Group Americas, Inc. We are a consignor of goods to the debtor, specifically sewing patterns. My client has approximately 11 million units at the over 800 stores across the country. I was able to work with Mr. Mahalik, and thanks to him for this, to put protective language into the cash collateral order. It's found in paragraph 31, which essentially recognizes that the pre-petition senior secured creditors are not obtaining liens over the consigned goods or the proceeds of the consigned goods. Moreover, the way the agreement functions is essentially when consigned goods are sold, it's reconciled on a weekly basis and my client is paid out. What the paragraph contemplates is that my client will continue to be paid in the ordinary course of business, and the payments of its cash collateral will be made outside of the budget. So they will not be included in the approved budget because it is not the collateral of the senior secured lenders. And I raise this because the debtors are approximately 4 weeks behind in their obligations. They stopped making payments approximately the middle of December. And so subject to reconciliation with Mr. Mahalik, we believe there's about $760,000 of cash collateral they're holding that would be payable out to my client.
Okay, but it sounds like you believe that the language you've negotiated and is in the current form of order is appropriate, and that you're just making the record clear, but you're not objecting to the order as proposed.
That's correct, Your Honor.
Okay. Is there any other party in interest that would like to be heard with respect to the interim approval of the use of cash collateral? Okay. Look, seeing no other objections and having ruled as I have on the objections that I've heard, I am satisfied that as a form of interim relief that this order is appropriate, and we will go ahead and enter the order. I want to emphasize this is interim relief and that none of this prejudices the rights of any party with respect to objections they may have to final approval, and I'll consider those on the merits and do my best to call balls and strikes if and when those objections come in. So, Mr. Mahalik, I'm happy to have you continue to the next motion.
Thank you very much, Your Honor. Fortunately, you've had enough of me for today, so I will turn the podium over to my colleague, Ms. Blumenthal.
Okay, thank you, Mr. Mahalik. I look forward to mispronouncing your name when I see you again. Ms. Blumenthal, let me give you the chance to be heard.
Yes, thank you, Your Honor. Good afternoon. For the record, Lindsay Blumenthal from Kirkland & Ellis, proposed counsel to the debtors. I'll take us through a few of our motions and then cede the podium to my colleague, Ms. Acuna. First, I'd like to go ahead and start with the debtor's motion for relief to pay pre-petition employee wages and benefits. This is agenda item 5, filed at docket number 7. Earlier this afternoon, the debtors filed a revised form of order at docket number 81, reflecting further resolution with the U.S. trustee. I know you noted you didn't get a chance to review, so I'm happy to walk you through those small changes. The debtors employ about 19,000 individuals, and about 17,000 of those work in our 800 stores. So we're not seeking approval today for payment to any insiders for bonus, retention, or incentives, or any approval for payments that exceed the priority cap amount. We're just looking to assure employees that their wages and benefits will be covered in this case. As I mentioned earlier, we worked with the U.S. trustee and counsels to the ABL and FILO agents to address their comments. I'm happy to walk through the programs in more detail and answer any of your questions. If none, we respectfully request entry of this order.
Okay, so I actually have now seen the changes, so I don't myself have questions, but let me ask, is there any party in interest that would like to be heard with respect to the debtor's motion seeking authority to pay pre-petition wages? Okay, seeing none, I have reviewed that motion and order, including the red lines, even though I've only seen the red lines briefly, but they're pretty limited, and I'm satisfied that the relief sought is appropriate, and we will go ahead and enter that order.
Thank you, Your Honor. Next up, I'll turn to the debtor's motion for relief to pay certain pre-petition claims to the debtors' store support vendors, their lien claimants, and their 503b9 claimants. This is agenda item 6 and was filed at docket number 8. Again, earlier this afternoon, we filed a revised form of order at docket number 83, reflecting further resolution with the U.S. trustee. The relief that we're asking here for is very narrowly tailored to make those payments only necessary to keep the stores operating safely and efficiently to support our process here on the vendor side, and will be appropriate for a company of this size. Again, we work with the U.S. trustee and the lender parties here to address their comments. Happy to walk through any questions, and if not, we respectfully request entry of the order.
Okay. Is there any party in interest that would like to be heard with respect to the motion that's described as the debtor's store support motion? Okay, seeing none, I've reviewed the motion and the order, including the red lines. I'm satisfied that the relief sought is customary and appropriate and warranted under the circumstances of the case, and we will go ahead and enter that order on an interim basis.
Thank you, Your Honor. Moving right along to the debtor's motion to continue and modify its customer programs and honor certain pre-petition obligations. This is agenda item number 7, and the motion was filed at docket number 9. We filed a revised form of order at docket number 82. The debtors have typical programs for retail companies of this size, loyalty programs, gift cards, coupons, promotional sales, and during this interim period, we're not proposing to make any changes to those programs. We address comments from the U.S. trustee and our lender groups, and if there's no questions, we respectfully request entry of this order.
Okay, is there any party in interest that would like to be heard with respect to the debtor's motion seeking authority to honor certain pre-petition customer programs? Seeing none, I've reviewed that motion and order. I'm satisfied the relief sought is appropriate, and we will enter that order on an interim basis.
Thank you, Your Honor. Moving on and jumping down the agenda a bit to item number 11 is the debtor's motion to maintain its insurance programs, including its surety programs, and to pay any broker fees. This motion was filed at docket number 13. There's no revised order here. The debtors maintain insurance policies and surety bonds typical and customary for a retail company of this size, and we are simply seeking authority to continue these in the ordinary course. We worked with the U.S. trustee and the lender groups, and if no questions, we respectfully ask Your Honor to enter this order.
Okay. Is there any party in interest that would like to be heard with respect to the debtor's insurance motion? Okay. Seeing none, I've reviewed the motion and order. I'm satisfied that the relief sought is appropriate, and we will enter that order on an interim basis.
Thank you, Your Honor. Next up is the debtor's motion to provide adequate assurance for payment of utility services and also approve procedures to resolve adequate assurance requests. This is agenda item 12 and was filed at docket number 14. No revised order here. The debtors are proposing to fund an adequate assurance account and implement procedures to align with the requirements under Section 366. There's just very typical utility services here, and this interim order will help ensure minimal disruption to the debtor's services. So, absent any questions, we respectfully request entry of this order.
Is there any party in interest that would like to be heard with respect to the debtor's utilities motion? Okay, seeing none, I've reviewed the motion and order. I'm satisfied that the relief sought is appropriate, and we will enter that order on an interim basis.
Thank you, Your Honor, for your time. That's it for me. I will cede the podium to my colleague, Ms. Acuna.
Okay. Ms. Acuna, you can proceed. Except that you're on mute.
Good afternoon, Your Honor. Can you hear me?
I can. You can proceed.
A little better. Olivia Acuna of Kirkland & Ellis on behalf of the debtors, and I'll be walking you through the remaining items on the agenda. And apologies, we are going a bit out of order, but we'll begin with the debtor's claims and noticing agent application for Kroll Restructuring. This application is related to Kroll Restructuring Administration LLC's application to be appointed as the claims and noticing agent pursuant to 156C, effective as of the petition date, filed at docket number 3, and this is agenda item number 2. I do want to note that we filed a revised exhibit a little earlier today at docket number 87. This was, again, just to correct a missing page in the exhibit attached there, too.
Got it. Okay, and I've got that. Thank you.
Okay, great. So as a preliminary matter, attached as Exhibit B to the application is the declaration of Mr. Benjamin Steele in support of the application. And Mr. Steele is on the Zoom line today, and I would ask to move his declaration into evidence for purposes of this application, subject, of course, to parties' rights to ask further questions.
Okay, is there any party in interest that would like to be heard with respect to the introduction into evidence of the Steele declaration in support of the claims and noticing agent motion? Seeing none, the declaration is admitted into evidence. Is there any party in interest that would like to cross-examine the declarant? Seeing none, Ms. Acuna, you can proceed.
Great, thank you. So the creditor matrix in this case has more than 200 creditors. So pursuant to Local Rule 2002 1F, the debtors are required to retain a claims and noticing agent. And the debtors also complied with the claims agent protocol and received quotes from 3 claims and noticing agents, and ultimately selected Kroll because of their competitive pricing and expertise. So unless Your Honor has any questions, the debtors respectfully request entry of the order.
Is there any party in interest that would like to be heard with respect to the motion, debtor's motion to retain Kroll as claims and noticing agent? Okay, seeing none, I've reviewed the motion in order. I'm satisfied that the relief sought is appropriate, and we will enter that order.
Great, thank you, Your Honor. Up next is the debtor's creditor matrix motion filed at docket number 4, and this is agenda item number 3. So pursuant to this motion, the debtors seek approval of the form and manner of service of the notice of commencement to redact and withhold certain confidential customer information and authority to serve certain parties by email. We received comments from the United States Trustee's Office regarding providing service via email, and I wanted to start off by taking a moment to explain to Your Honor why the debtors believe it's not only appropriate, but also prudent to serve parties via email in these cases where we can. As you've heard from others today, the budget in this case is tight, and the debtors are closely managing that budget. And given the number of notice parties in this case, the cost associated with providing hard copy notice via mail would be extraordinary, to say the least. So in an effort to save costs, the debtors would like to notice parties via email when possible. To be clear, if someone specifically requests hard copy service, we would, of course, accommodate that request. Additionally, if we don't have an email address for a party, we would provide notice via mail. And again, the debtors are seeking this relief as a cost-saving measure because we're closely managing the budget. And I'll pause there and turn it over to the United States Trustee's Office, as I understand they may have comments.
Okay, Mr. Bates.
Hello again, Your Honor. For the record, Malcolm Bates on behalf of the U.S. Trustee. Your Honor, I'll be brief. While acknowledging the concerns raised by the debtors in this case, our office, of course, works within the confines of the code and the bankruptcy rules, which require service by mail unless a party consents in writing to notice via electronic service. The proposal by the debtors would invert that structure so that a party receives electronic notice unless it requests in writing to receive notice by mail. And so we simply object to enter these to the extent that it seeks approval of email as the primary form of service.
Okay, let me, so Ms. Acuna, you propose email service. Is that limited to parties who had conducted business with the debtor pre-petitioned by email and consented to basically be notified by email?
So, Your Honor, we can add language making that explicit to the order. So right now, the way that the language is phrased, it would authorize us to serve all pleadings and papers, including the notice of commencement, via email. But if Your Honor would prefer that it's clear that parties that have previously consented.
I do think that Mr. Bates is look, whether what the rule says or the statute says is what it ought to say is a different question. But I think I'm left with enforcing it in the form in which it exists. And I do appreciate the cost concerns and, don't at all minimize that, particularly in the context of this case. I think that what I've been comfortable with before is that to the extent a party in interest had, on a pre-petition basis, given its consent for email notification, that's fine. Any party in interest that otherwise, on a post-petition basis, gives its consent to email notification, that's fine. But I think as to someone who has never said, I'm cool with getting communications by email, unfortunately, I don't particularly think what the statute and rules say is necessarily a good idea, but I don't think I get to say you don't have to follow it because I think it's a bad idea. So I think in the absence of some expression of consent, either on a pre-petition or post-petition basis, mail service is unfortunately required. So again, to the extent the debtor, we're talking about customers with whom the debtor was doing business pre-petition, you may well have that. But I do think revisions in the order to reflect that would be appropriate.
Understood. And just to echo what you just mentioned here, I do believe that a large number of the parties involved here have already consented, given the nature of their relationship to the debtors. But we can absolutely add that language.
Okay, very well. And I think that language like that I've approved before. I don't know if that's at the consent of the U.S. Trustee's Office or over their objection, but I'm comfortable with that as being in accord with the statute and the rules. So I think with those changes, if the parties could just confer about a form of order that reflects that, I'm fine entering it on that understanding.
Okay, understood. We will revise and run this by the United States Trustee's Office as well and submit that.
Okay, very, very well. Mr. Bates, do you need that under certification, or if it's uploaded, if I take it being uploaded as a representation that you have signed off, will that suffice as a process matter?
That's fine, Your Honor. Thank you.
Okay, all right, very well. So I don't need a separate certification. I will take it being uploaded by Delaware Counsel as a representation that Mr. Bates has signed off on it.
Okay.
And anything, what's next on the agenda?
Next on the agenda is the debtor's cash management motion filed at docket number 10. And we did file a revised proposed form of order earlier today at docket number 85. And this is agenda item number 9. So pursuant to this motion, the debtors are seeking entry of an interim order authorizing the debtors to continue to operate their cash management system, maintain their existing bank accounts, honor certain pre-petition obligations related thereto, maintain their existing business forms, and continue to perform certain intercompany transactions. And we attached a schematic to the motion, which is illustrative of how the cash management system works, but I will walk you through a brief high-level overview of the system, just to touch on the highlights. So the debtors maintain 826 bank accounts, all of which are owned and controlled by the debtors, and are spread across 8 banks. 803 bank accounts are store depository accounts on behalf of the individual stores, and then these accounts are swept into 6 depository accounts. We did receive comments from the United States Trustee's Office and other stakeholders, and all comments have been resolved and are reflected in the revised proposed form of order that was uploaded earlier today. So unless Your Honor has any questions, we'd respectfully request entry of the order.
Okay. Is there any party in interest that would like to be heard with respect to the debtor's cash management motion? Seeing none, I reviewed the motion in order, including the red line that came through. I'm satisfied that the relief sought is appropriate and customary, and we will enter that order on an interim basis.
Thank you, Your Honor. Up next, then, is the debtor's taxes motion filed at docket number 12, and this is agenda item number 10. We also filed a revised proposed form of order earlier today at docket number 86. And pursuant to this motion, the debtors are seeking entry of an interim order authorizing the debtors to pay taxes and fees in the ordinary course of business as they come due. So in the ordinary course of business, the debtors incur income and franchise taxes, property taxes, sales and use taxes, customs and import duties, licensing and permitting fees, and fees to a third-party tax provider. The debtors estimate that approximately $33.5 million in taxes and fees is outstanding as of the petition date, of which approximately $27.9 million will be owed during the first 21 days of these cases. And we received comments from the United States Trustee's Office, and all issues have been resolved, and they're reflected in the revised proposed form of order. So unless the court has any additional questions, we'd respectfully request entry of the proposed interim order.
Okay, is there any party in interest that would like to be heard with respect to the debtor's taxes motion?
Yes, Your Honor.
Yes.
I apologize. I'm working to get my camera on. Maura Russell of Leishman Law, PLLC, on behalf of West Broadway Distribution Services. They are a consignment vendor. Certain language was addressed in the cash collateral order, similar to the IG. Consignment vendor in terms of preserving our liens in our collateral. I would just ask that the language that was added to paragraph 23 of this order also apply to West Broadway Distribution Services.
So I'm sorry, it's possible I'm confused, but this is the order about authorizing the debtor to make pre-petition tax payments, right?
No, Your Honor, I apologize. I don't know. I thought we were still on the order dealing with the, I apologize, on the cash management system. I apologize, Your Honor.
All right. So let me come back to you after we address the other issues and see if there's a dispute.
Absolutely. My apologies.
No, understood. No problem. Okay. So is there any party interest that would like to be heard with respect to the debtor's motion seeking authority to pay certain pre-petition taxes? Okay, seeing none, I have reviewed that motion in order, including the red lines. I'm satisfied that relief is appropriate, and we will enter that order on an interim basis. Ms. Acuna, is there more on how I lost track? By virtue of the jumping around. Okay, very well. Let's do that, and then Ms. Russell will come back to your issue.
Absolutely.
Okay.
Thank you.
Okay. What's next?
So last but not least is everyone's favorite, the debtor's NOL motion filed at docket number 10. And this was agenda item number 8. And we filed a revised proposed form of order at docket number 84. So in the ordinary course of business, the debtors accrue various tax attributes, including net operating losses and 163J carry forwards. However, in the event of a change of ownership, these tax attributes may be negatively impacted. Therefore, the debtors are seeking relief, which is intended to preserve the value of the tax attributes by establishing certain hearing and notification procedures related to the transfer of stock in the event a change of ownership is triggered. We received comments from the United States Trustee's Office, all of which are incorporated in the revised proposed form of order. So unless Your Honor has any questions, we'd respectfully request entry of the interim order.
Okay. Is there any party in interest that would like to be heard with respect to the debtor's NOL motion? All right, just give me a second as I look at the red line. Okay. Okay, so seeing no objection, I've reviewed the motion and order. I'm satisfied that this relief is appropriate. It's certainly customary, and we will enter that order on an interim basis.
Great. Thank you, Your Honor. And I believe there may be another point counsel wanted to
Ms. Russell wanted to raise. Ms. Russell, is your issue with respect to the cash collateral motion or the cash management motion?
No, Your Honor. Our issue had initially been dealt with in part in the cash collateral motion, which was included in paragraph 31 of that order. So we were all set on that. The next comment that I have is on this cash management order at paragraph 23, where there was a similar carve out and protections afforded to a consignment vendor, IG Designs Group at paragraph 23, basically, where the proceeds from the sale of our collateral will be segregated. There'll be reconciliation and payments on a post-petition basis consistent with how the agreements provide. And we just would ask that that language also apply to West Broadway Distribution Services.
Okay. Ms. Acuna, I guess that was your motion. Any objection to making that revision?
No objection to the revision. We can include you in that language.
I appreciate it. Thank you very much.
Okay.
Thank you. I'll pass it over to Mr. Mahalik.
Okay, Mr. Mahalik, where to from here?
That's it, Your Honor. I got the distinct pleasure of wrapping us up today.
All right, so can we talk about some logistics before we disappear? So you're going to need the date of a second day hearing in order to drop it into the orders that you're going to upload. I know there was a conversation about holding February 14th. Is that the date you're asking for a second day, or would you like to do that some other time?
No, Your Honor. I believe, and Patrick just rejoined us, I believe we reached out ahead of time to reserve some time on your calendar for February 11th for the second day hearing.
That is fine.
And then February 14th would be our proposed sale hearing.
Got it. Okay. And I believe February 11th, you said at 2 p.m. is the note that was handed to me, and when I'm given very clear direction, I tend to do okay. So any objection by any party to setting the second day hearing on February 11th at 2 p.m.? Okay, so why don't you go ahead and we'll set it for then, and the orders that the interim orders should so provide. In terms of the mechanic of getting the first day orders uploaded and entered, Mr. Riley, I guess I want to be sensitive to what needs to, if there's anything that needs to hit the docket tonight, I'd like to just make sure we're, sensitive to that and are ready to go. So where do things stand?
So I'll let Mr. Mahalik speak to if anything absolutely needs to be entered tonight, but during the hearing, my office started uploading the orders, so you would have them. We did include the February 11th second day hearing in the line item, as well as an objection deadline of 1 week before, sort of consistent with the local rules.
It's fine.
So the majority of the orders, if not all, have been uploaded. Cash management may have been uploaded too. We were trying to do it in real time. So once the revised order is uploaded, I'll send your chambers an email if that's acceptable.
That's fine. If you email Ms. Barksdale with the form of order, that's fine. I guess I just want to make sure that with respect to the use of cash collateral, which is the one that is probably the most likely to need to be entered today, has that been uploaded?
That one's in process to be uploaded if it's not already.
Okay. And if we're certain to get that entered today and the others either today or tomorrow morning, will that risk any operational harm to the estate?
Your Honor, I think in terms of priority, we would want and ask for cash management and cash collateral to be signed and posted for today.
Okay.
No issue from my perspective if the others have to linger until tomorrow morning.
Okay, very well. So we'll make sure
we'll get those uploaded as soon as possible.
Okay. So in my taking credit for Ms. Barksdale's work, which is really what I mostly do for a living, we'll make sure that we get that done. And obviously the sooner they're uploaded, the easier that is. Okay. Is there anything else that I can do today that would be helpful to the parties or to the process?
That's it, Your Honor. Thank you again.
Okay. Any other party in interest wish to be heard while we're here? Okay. Seeing none, look, I appreciate there are issues ahead of us that may turn out to be complicated, but I do appreciate the good work that was done to focus today on what needed to be addressed today, and we'll address tomorrow's problems tomorrow. But really with my thanks for the good work in connection with first day relief. Appreciate that. I'm sure I'll get a chance to see everyone here in Wilmington before long. So with my appreciation, we are adjourned. Thank you.
Thank you.